All right, everyone. As you already heard, my name is Elan. My firm is EJD Law Group. I am an attorney specializing in several different areas of the law. The very first one, by far the biggest one in my practice, is construction law. That is the reason I joined this group several years ago. I think I've told you before that contacted Paul, told him kind of what I do, thinking that this may be a good fit. One of the best decisions I've ever made was to join this group. So I'm very thankful to Paul and all of you for welcoming me. So some of the things that I do specialize in with respect to construction are contracts, disputes on jobs, kind of like what I talked about today, payment disputes. You have that difficult client that doesn't, want to pay. Mechanics, lien, stop notices, that goes hand in hand with that. If there are ever claims against my client's bonds, I represent them in that. Supplier claims. Now, I know that none of you have ever dealt with any of these things, but if there are ever defective construction claims, I also represent my clients in that. So I kind of, with respect to my construction practice at least, tell my clients, for 95% of my contractor clients, I would say that I act as outside general counsel, where I'm kind of the one-stop shop of, whether it's a big job or whether it's something that pops up on a specific project where it needs to be a 2-minute phone call of, hey, Elan, I had this one thing come up. What do you think? That's kind of the way I like to work with my clients. Some of my clients, it's just specific scopes, but most of my contractor clients, it's just kind of like general counsel. I'm able to handle almost anything when it comes to construction law side of things. Of course, there are specific things that come up every once in a while that, I'll say, hey, I don't handle that, but more often than not, I have somebody who can handle that if it's not me. So that's kind of my construction practice in a nutshell. Next biggest one is general business law. I know I've talked about it before, business formation. And then after you form the business, there's a lot of people out there, a lot of business owners that think, okay, I formed the business, that's it, I'm done. No, there's actually a lot of things that should be done. You got to maintain your corporate formalities. And a lot of people don't think it's a big deal. And it's not a big deal unless something happens. And that's kind of how it always is. And the whole point of maintaining corporate formalities, and that's things like having shareholders meetings, having minutes of those meetings. These are all legal requirements, because if something is to ever happen down the line where your company gets a judgment against it for whatever reason, if you don't maintain your corporate formalities, there is an actual legal process. I'm sure many of you probably heard of it, but you can pierce the corporate veil, which again, everybody forms a business entity for the purpose of liability protection, to not being able to go after the owners of the company, the personal assets. Well, if you don't maintain your corporate formalities, there is a way that actually they can go after you personally. It's difficult, but there is a way. So, I always advise my clients to make sure you're doing those types of things. It's not difficult, but it's important. Also help with kind of same thing, contracts, disputes, partnerships, disputes, drafted buy-sell agreements, stuff with payment. And again, I do both transactional and litigation. I do a lot of real estate work, development. Lately, there's been a lot of lease issues, landlord-tenant disputes. I've had a lot of those lately. Mostly, I represent landlords by far. I have helped some tenants out, but it's mostly on the landlord side. Some quiet title actions. I got a couple of those right now where people are trying to steal title to property. Foreclosure, land use, easements, and again, transactional and litigation on that. Then insurance coverage. Now I know it's a super broad term, but when I say I do insurance coverage work, that's helping either business owners, most of the time it's homeowners, with insurance claims that have been wrongfully denied or grossly underpaid. I know you've all heard Amjad come in and speak that they specialize in mold and water damage restoration, remediation, and that's usually after insurance claim. So if there's ever, they make a claim, you have a leak, you may claim your insurance company, you think they're going to come in and pay. Oftentimes they don't, they find some way to deny the claim. That's where I come in and help them. Or again, they only want to pay for a small portion, also help them with that. And pretty much any kind of insurance claim, I can handle any of those. Now, this is a part of my firm. I don't advertise very much. I don't talk about it too much. But it is something that I certainly have the ability to do. I have a lot of experience in it, and that's personal injury. It's not my favorite area of the law. It's not the most exciting, in my opinion. There's a lot of people that love it, but I definitely have a lot of experience in it. I do handle it. So if, again, you guys do know someone that's ever been involved in any kind of accidents, I can definitely help them with that as well. And, again, pretty much any kind of accidents I can take care of. Now, a topic I wanted to talk about, minus the just what about my firm and what we do, is something that I think could be beneficial for most of you. I know not all of you are contractors, including myself, so this probably doesn't apply to you, but it does help all the contractors in this group. And I've talked about it, I think, once before, but it was when we were still on COVID times on Zoom, and we were split into two groups, and the group was much smaller. So I wanted to talk about it again, and I've added some stuff to it because I think it'd be super beneficial for all the contractors in this group, because I'm sure you guys are knowledgeable as to mechanics, liens, and stop notices as contractors, as being in the business for a long time, but maybe I can just refresh a couple points, and if I can do that, I think I've done my job, because it's very, very important for any contractor to know the lien process, because hopefully no one ever has to use it. But again, if there's that client that doesn't want to pay, that wants to stiff you, this is a very, very effective way, in my experience, of getting them to pay, because it gets a lien on their property. I'll talk about a little bit of the differences at first of what a mechanics lien and stop notice is. They're both ways or procedures for a contractor to be able to get paid on a job. Mechanics liens, they actually attach to the property, so the project, whatever that is, you can attach a lien to it, while a stop notice, that just attaches to funds that are being held by, most of the time, the owner of the property, or if it's a bigger project, maybe there's a lender on the property. So that attaches to the funds and just creates a freeze on the funds. So if there's a stop notice, whoever it is that's holding the funds, really can't release them until everything gets figured out, until everyone gets paid. So that's the main difference of the two. Most of the times you're dealing with mechanics liens, but sometimes there are stop notices. Who can record either a mechanics lien or stop notice? Pretty much anybody who's working on the job. So direct contractors, another term for general contractors, subcontractors, suppliers, design professionals, so architects, engineers, again, pretty much anyone working on a job, as long as you're licensed, can record mechanics lien or have a stop notice. Now, public versus private projects makes a difference, because stop notices are available on both, while mechanics lien are only available on private projects. So if you're doing public work for city, county, whoever it may be, mechanics liens are not available under those projects.
Is it true that if you work directly for an owner, you don't need to file?
So what you don't need is, and that's on this slide, is you don't need to do a preliminary notice, but you still have to record a mechanics lien if you want to foreclose on it. So that is the difference, though, for the preliminary notice. So one of the first requirement to be able to record a lien and then later foreclose on it and enforce it is you have to serve what's called a preliminary notice. Has to be within 20 days of starting work. And the whole point of this preliminary notice is just to give the owner of the property, of the project, notice of who is actually working on the project, so they know. So on to Pierre's point, a general contractor or direct contractor doesn't have to serve preliminary notice, because it's kind of counterintuitive. The owner of the project, or whoever's hiring the general contractor, obviously knows that person is working on the project. So you don't have to go give them a preliminary notice, because they already know. But again, if there's a bunch of subcontractors underneath that owner doesn't know is even really working on their project, that's why they, suppliers, any of those types of people have to serve the preliminary notice in order to even preserve their right to record a mechanics lien, because the requirements are really strict. I've seen a lot of times where this process isn't followed, and then they go file a lawsuit to try to foreclose on a mechanics lien, and they're able to get out of it really quickly because they didn't follow the proper procedures, and they're super strict. So that's why I always tell my clients it's important that you do this correctly, or else you're kind of out of luck. Now, who must be served with a preliminary notice? The owner. If it's a subcontractor, you have to serve the general contractor, so the general contractor has it too. And again, if it's a bigger project, there's a lender also have to serve the lender. So that all depends. And then you have to do service a specific way, either personal delivery, so actually handing it to them, or by mail. But again, if it's by mail, it's got to be registered, certified, express, or overnight. So it can't just be snail mail. That's not good enough. So again, got to make sure that you comply with these requirements. Now, there's also specific time limits that you have to record a mechanic's lien. So you got to know these and make sure you're doing it within these time limits, or again, you're out of luck. Most projects, at least I've seen, they don't, get notices of completion that are actually filed or recorded. So this is going to be generally the timetable that applies for most projects. So if there is no notice of completion that's actually filed or recorded, then generally it's 90 days for the most time. It's 90 days from actual completion of the whole project. Or if, let's say, your specific work was done way before than the whole project was done, it's 90 days after or within you finish your work on the project. So it's not just, if you stop work towards the beginning of the project, but the project still has another year to go, you can't just sit there for a year and say, I'll record later. It's got to be 90 days within your specific scope that stopped working on the project. So it's not, 90 days, so you got 3 months, but again, just know that 90 days is in there so you don't sit on it for too long, because then, again, out of luck. There are a couple other ways where it says here cessation of labor, just fancy term for stopping work. So it's generally, again, that 90-day period. If there is a notice of completion, then you either have to record within 60-day notice of the completion recording date for general contractors and 30 days for subcontractors and suppliers. So it's a shorter period. That's why you kind of got to know, is there a notice of completion that's being filed? Just kind of keep your eye out for those things. So that's just the recording of the mechanic's lien. The next step is to actually foreclose and enforce the mechanic's lien. And all that means is you have to actually file suit in the Superior Court to enforce that, and that must be done within 90 days after recording your lien. So you have the preliminary notice, then you record your mechanic's lien. Again, if you get paid, obviously no need to do it, but if you're not getting paid, you record the mechanic's lien, and then you must file this lawsuit within 90 days, or again, you'll lose your right to do that. So that is a very important deadline, because the statute of limitations will expire, and out of luck. Stop notice, a little bit different on the timetables, but the process itself is pretty much the same. And again, it does make a difference whether it's a private project or doing public work. For private work, if it's a general contractor or prime contractor, no later than 60 days after a notice of completion or notice of cessation was recorded. Or, like I said, if none of those are recorded or filed, 90 days after completion of the work. If you're a subcontractor or supplier, not later than 30 days after notice of completion or cessation, or 90 days, again, same thing, if none of those are recorded. On a public work, actually a general contractor has no rights to give a stop payment notice on a public work, but subcontractors and suppliers still do, not later than 30 days after notice of completion or cessation, or 90 days after the public entity actually accepted the work, or when no work has been done for 60 consecutive days. And then same thing, lawsuit must be filed within 90 days after delivering the stop notice. So I'm sure you see the pattern is the 90-day mark. There's a lot of those 90-day marks, and that's kind of the rule of thumb. But again, make sure that you or whoever it is that's handling for you guys are aware of these deadlines, because they come up on you, and you have to make sure you're complying with them. Now, last but not least, who can enforce mechanic's liens? And I touched on this earlier. Only licensed contractors have lien rights. So, no contractor out there who doesn't have any license, or who doesn't have a license for the specific work that they're performing, they cannot go and record mechanic's lien. I mean, well, I guess they can, because you can record anything, but they're not going to be successful on foreclosing or enforcing it, because again, they're not licensed. They do not have any lien rights whatsoever. So again, California is really big on only licensed work being done. This is one of the things they do to persuade everyone from getting the proper licenses, or dissuade individuals from working without a license, because they have no lien rights. So They can't do any of these things that we just talked about. Now, to go a little bit further on the whole license issue, Business and Professions Code 7031, that's the specific statutory code that talks about licensure in California. And again, because California tries to do everything in their power to persuade everyone from having a license, they have some of the strictest laws in the entire nation, in the sense of an unlicensed contractor, and I guess then they wouldn't really be a contractor if they're unlicensed, but an individual doing unlicensed work have absolutely no rights, not only to foreclose on any liens, but they have no rights to even file suit for non-payment. If you read 7031 subsection A, it says no person engaged in the business or acting in the capacity of a contractor may bring or maintain any action or recover in law or equity in any action in any court of this state for the collection of compensation for the performance of any act or contract where a license is required by this chapter. So again, in other words, if it's an unlicensed contractor or person doing work that they're not licensed for, and that client says, I'm not paying you, they cannot go and sue them and go ask a court to give them a judgment of, hey, I did this work for this person, they need to pay me. And the judge or the jury, whoever it might be, could say, well, are you licensed for that work? No? Well, too bad. Sorry. I mean, you should have gone and gotten a license because of 7031A. So, people doing work without licenses can get really, really, screwed in these situations. So that's why, again, I only deal with licensed contractors, but if I ever get someone that comes across that isn't licensed, like, go get your license, because it could cause a lot of problems. Now,
well, I have a question. I deal with this all the time.
Yeah.
Can you also talk about what a legal 1099 is? Because a lot of contractors don't know, and I have to educate them. And they say, oh, I 1099 that guy. I'm like, that's a crime.
Right, exactly. That's a different issue, but yes, that happens all the time. And then 7031B, it's kind of that exact thing, but inverted, in that if somebody hires someone to do work on their home, it could be a commercial property, whatever it might be, and that person is unlicensed, or again, unlicensed also means, let's say you hire somebody to act as a general contractor, but they don't have a Class B license. That's also an unlicensed individual. They can't be a swimming pool contractor, acting as a general contractor. That's also considered unlicensed work. So if someone hires an unlicensed contractor to do work, they can sue them and recover every penny that they paid to that individual. It doesn't even matter if the work was pristine and perfect. They could go and get every, penny back. I've seen it happen. Again, I think it's tough, especially when the work is good. But for example, you hire someone to do a remodel on your home and you pay them $200,000, and at the end of it, you're still very happy with the work. The work is good. If you wanted to be extremely, tough, and you found out that persons were unlicensed, or even if you knew the person was unlicensed the whole time, you could still sue them and say, I want every penny of my $200,000 back because they were unlicensed. So again, it's super, super harsh, but California put these things into place to persuade everyone for getting the proper licenses, having the proper insurance, and do everything under the license statutes. So that is it in a nutshell. I wanted to end with that. And again, obviously everyone here, of course, I know is licensed, but if you guys have any colleagues that are doing any type of stuff, talk to them about this, because it could cause a lot of problems. So that is my presentation in a nutshell. I hope you guys got something out of it, because it's important. Any questions?
Notices of completion. Is that something that an owner would file? Who would file that?
Generally, it's an owner, but if it's obviously the owner who's hiring a general contractor, for example, who's handling the project, it would be the general contractor obviously telling the owner to file it. Sometimes I've seen the general contractor do themselves, but it's generally the owner's responsibility to file that.
Okay.
Yeah.
And then if you say you don't get paid as a general contractor, when you say you record a mechanics lien, can you literally go down to the county recorder and record a lien?
Absolutely, yeah.
Does that show up on title if there's a title search?
100%.
Even though you haven't had a judgment against it.
Correct. So what you need to do is again, this is if the lawsuit's ever foreclosed or enforced. You file the lawsuit. So within 20 days of filing the lawsuit, again, this is already for the attorney to do. I would assume that everyone would hire an attorney to do this. But we have to file a lis pendens within 20 days of filing the lawsuit, which that is also recorded in the county recorder's office. So if someone ever goes and pulls title, they see there's a mechanic's lien, and then they see the lis pendens, which is just a fancy term for notice of pendency of action. So now they see, oh, there's an actual lawsuit against this property. So, again, any prospective purchaser would see that is there. And the county recorder's office, they are not going to decipher whether it's a valid document or not. You go there, you pay the fee, they'll record anything. So it's as simple as that.
Yeah, and then on the loan side, of course, that's like a showstopper for any refi or anything else. Like, you'd have to take care of that.
Right.
As part of the
It's
process
got teeth
or
in it.
whatever.
Yeah.
It's without any judgment? You can do that?
Correct. This comes before the judgment. Yeah.
And that shows up on title.
It shows up on title. Yeah. So.
And then, a stop notice. Can you put that to an owner that's using his own funds and is the bank? So
Correct.
How does that work? I know about if there's a lender, the lender will stop lending on it.
Right.
But you can freeze owner's funds.
So you can, again, 95% of the time that at least I've seen it, it's been where there's a lender.
Yeah.
Because there's somebody holding a big pot of money and you don't want them to start paying it out. But you can do it with an owner if they're funding it themselves too. But it's not common. It's like, that mostly it's the mechanic's lien because it has more teeth. Has a lot more teeth, but if there's a lender, the stop notice actually is better. So it really depends on how the project is being funded on what's the best course of action. Johnny?
This question is kind of to the general contractors in the room. So we tend to try and align with general contractors that we trust, right? And I think that's probably true with everyone. So right now, all the GCs that we work for, we trust, and we don't file preliminary notices. But my question would be to like Paul, Pierre, Raphael, GCs. You're working with a lot of different subs. You got plumbing, electrical, HVAC, flooring, paint. If my company, let's just say Malabar, for example, files preliminary notice with you as a matter of just good business diligence, right? Does that put you in an awkward position because your other subs don't, and the owner's going to be like, well,
No.
how come it does? So that's
No.
you're okay with that? Because I wouldn't want to put you in an awkward position.
Completely fine with it because who does typically file preliminary lien notices, and your concrete suppliers, Ganal Lumber, all of the big material suppliers, they just do that as a matter of course. You open up a new job account, they get all the information. We explain that to the owners that this is just saying, hey, these guys are going to be providing goods and services, they have a right to be paid. And it says it right in the front of that prelim lien notice. This is not a reflection of anybody's, credit worthiness. Sometimes it'll scare somebody, but we tell them ahead of time. Most people
I
get
got
it.
this from the client in Marwood. She was super worried. Got a mail from Ganal Lumber
Yeah.
with the
Right.
preliminary.
You read it and it's
I
like,
said,
whoa,
no,
who's not getting
I
that?
explained exactly what you just
Equipment
did.
rental companies do too. Like if you get
Yeah.
like a big scissor lift or something on site, they
Right.
want to get paid.
Right.
But you get a release from the,
Correct.
after you pay.
Now, what then we as general contractors need to do is, as we pay Ganal Lumber, concrete suppliers, we
waiver.
get their, if they do a preliminary lien, excuse me, then we make sure and get those conditional waivers of release upon a progress payment, meaning it's conditional that the check clears. And then, so, especially if there's like a construction lender, they're really good about making sure that you're providing all the lien releases, and that's just part of the paperwork of being a general contractor.
Or you can do a joint check.
Joint
Yeah.
checks too, sure.
But I had that problem with the roofer ones, and I asked him to give me a release. And then about 2 or 3 months later, the roofing supplier sent me a request
bill.
for funds. I said, no, I have the release.
Yeah.
Oh, so the roofing supplier had signed the release and then asked for it?
No,
The sub did,
the sub did.
but the sub didn't pay the roofing supplier. So that roofing supplier has total rights, and you as a GC need to defend your, but did the sub ultimately pay?
I didn't,
Oh.
I didn't pay.
That can be a problem for an owner.
Yeah.
The best way that I've found to deal with it is just constant communication. Be honest, just make sure you're paying everybody. And then for us, if somebody doesn't file a prelim, it's that check that, gets cleared or the payment is shown. So.
Yeah, I'd
But-
say communication is
Yeah,
definitely
communication's
the
huge
key.
in
But
business.
if you paid without a release, you're screwed.
No, because you can prove that you've paid because the check clears.
Yeah, but, you pay
Okay,
the
so if you
sub.
pay the sub and the sub doesn't pay his material suppliers, yes, you are screwed.
Yeah.
The owner's screwed, and you're in the driver's seat of that.
Yeah.
And so there's a lot of honesty, and there's just a lot of built-in trust, because all of this paperwork takes so much time to track and do, and we're trying to run our businesses but yeah, if somebody didn't pay their supplier, but that supplier has to prelim lien, and so there's a process that they have to go through to protect themselves. And if that roofing supplier did not prelim, and 20 days goes by,
Yeah.
they're out of luck.
Yeah, too bad.
So it's the ones that prelim that we need to pay attention to as GCs. And any sub here, fine to let you guys prelim. So if you're working with a new general, or you're working with somebody you haven't dealt with before, and you're not directly connected to the owner, that's when you want to file a prelim. So, and there's services that'll do it for not much money. You just
Yeah.
give them all the information.
Yeah, absolutely. That's why, like you said, all the big ones like Ganal, they do
They
it
just
all
do
the
it as a matter
time,
of course.
literally all
And
the
it
time,
totally
and
protects
it's smart.
them.
I
It's
mean, that's
smart.
the way to, it's a
Yeah.
smart way to do it. So, Andy,
Great presentation, by the way, Elan,
Thank
super
you.
informative. So I have a question. With a letter of authorization from a licensed contractor, could I record a mechanics lien on their behalf down at the county?
yeah, absolutely.
Yeah, I don't
Definitely.
even know if you'd need that letter of authorization. You could probably just go down and record it, and they wouldn't ask.
Yeah, honestly, because you and I know spoke about this on a coffee break before, but I literally did this last week. I had a client who were foreclosing on a mechanics lien first. I'm recording it for them, but I send it to my legal service company, the DDS,
Right.
that does all my legal services. I sent them to this. I said, hey, I need you guys to go record this at the whatever county recorder's office. And they just send a runner to go down there and do it. So that's exactly that. You don't even need a letter of authorization. They just send a runner down there. I need to record this. They get the stamp and they send it back to me. That's it. So it's a pretty simple process.
So most of my work is direct to the homeowner. So you're saying if I get a homeowner who owes me $5,000, $4,000, whatever, and they refuse to pay, I don't have to have a prelim. I can just go right to and record a mechanics lien.
Correct. Because you're the direct contractor. So the owner knows you're obviously, Burke's Custom Painting is working on the project. So you don't need to prelim them. You can go directly to recording of the mechanics lien.
Can I use a prelim notice in my hand and demonstrate to the client just as a tool to try to encourage them
It's
to
your
complete
contract.
the payment?
You can, yeah. So there's nothing wrong with doing it. It's just you don't legally have to as a direct contractor. But yeah, if you want to, I guess, kind of maybe, show them that this is the process and I'm serious, I'm going to go do this if I have to,
Because
yeah.
homeowners don't want that mechanics lien on a property.
Of course not.
And
Of
so
course
if you're
not.
showing them the prelim, I've used that before as a tool but I thought I had to file it.
No.
Never happened.
Not as a direct contractor. You don't have to, but again, there's nothing wrong with doing it.
I think it's only if you're the primary contractor, like a general, then or if you're working directly to the homeowner, it's your legal contract. Preliminary is mostly for subs, so if you're working for a general, then you need, like, as a sub, like a secondary, right?
Correct, because you might not know,
If
if
you're
there's a
dealing
certain
straight with the
sub.
homeowner, you're
Yeah.
primary, not a secondary, so your contract is the preliminary.
Got it.
Did you have a question? Sorry,
Yeah.
I didn't.
No, it's okay. Well, I just want to talk about, I know about insurance claims. Our paths cross all the time when it comes to, I write insurance. You have, obviously, on the other side of experience, share about why it's important to understand, insurance claims for contractors on general liability insurance.
Yeah, no. So on the insurance side of things, it's extremely important. That's why you got to get somebody like Kevin when you're looking for insurance, because as we've all heard Kevin speak, Kevin's not just going to go take you to whatever carrier will give him the highest commissions or whatever it may be. Number one. Number two, Kevin will actually read the policy that they're offering and make sure that you understand all the coverages, because for every few coverages, there are a million exclusions that they throw in there, and you need to be, for a lot of these policies, a Harvard, grad with 5 degrees to even understand what these mean, because they're so complicated. So yeah, it's not, just having insurance, that's great. You need to make sure you have good insurance though, with certain exclusions that aren't in there, because I know you've said that you've had some plumbing contractors that had water damage exclusions, and it's like, well, what most plumbers, if there's some damage, it's going to be water damage. So if it's excluded under the policy, you essentially are paying for insurance, but you're paying for nothing, because they're going to say, well, look at that exclusion, it's denied. So that's why it's important to not only have just insurance, but have somebody good that knows the policies, knows your exclusions, and making sure that you're actually covered for the specific work that you do, depending on what type of contractor you are. So that's, super important to make sure you have insurance that will be there if something does go wrong. Johnny, I think you had a question?
Yeah, real quick. So if the lien has been filed and you actually have a judgment, what's the process of foreclosure? Or do you just have to wait until they try to sell or get a loan on the property?
So foreclosing of the lien is just filing the lawsuit and then getting a judgment. Now, once you have the judgment, that's another.
Collections is another.
Exactly. So so that's the next. So you have judgment is good. You have a piece of paper that says somebody owes you a bunch of money. The next step is now collecting on it. A general money judgment is, there are a lot of different steps. If they have assets such as real property, you can attach to it, put a lien on it. If they have money in the bank, you can go to that. You can garnish wages. It depends. But in a lien foreclosure, once you have that judgment, if they don't want to pay, you can essentially force the sale of the property, and then you get paid out of it. Obviously, there's probably other lien holders there too. The bank is going to be number one in line. So hopefully there's enough money, if that you had to go that route, that the bank isn't going to take all of it and as being, the first secured creditor. But that would be the way to do it, and that's why the lien process has the most teeth, other than, I'm going to go sue you for breach of contract. That doesn't scare a lot of people. But when you say, I'm going to put a lien on your property and I'm going to foreclose it, and I can, force the sale of your property, that scares a lot more people. It has a lot more teeth. So that would be the number one way to actually go to the next step after the judgment.
Is there a statute of limitations on that once you have the judgment and you attach it to the property?
No.
So
So after that, the judgment is there. So a judgment doesn't just go away.
Okay.
Obviously, best practices are to try to move on it as quick as possible, but no, the time doesn't expire.
Don't they have to sell the property within a year if they don't give you any money? Isn't that the legal time frame or whatever?
No, they don't have to sell it within a year. So that's why it's kind of on you to go move forward and do what you need to do. Because if, again, a judgment is a piece of paper, same as a lien. It's there, but if no one does anything about it, it sits there. So that's why it's on you to take the next steps and make sure you do what's necessary to get paid.
Well, just adding on to that, isn't it, even though you had that lien, you have to sometimes go back and force the sale to happen in a certain time frame. So even if you had that, they don't do it, then you have to go back and get it forced.
Yeah.
So that might normally, depends, I guess every state's differently, but normally be like a 90-day force of sale or something like that, depending on what the judge agrees to and how litigation goes.
Well,
Thank you.
well,
Just a quick testimonial for this fellow here. He did my contract plus home contract. Great job. We're kind of polishing that. But what I want to tell you about him is that you all know the problem I had with the hospital bill for my daughter. A $400,000 bill that I got from Chalk Hospital. Long story short, I audit the bill. There was a lot of charging items there. First round negotiation with insurance, the bill drops to $137,000. But after that, thanks to Paul, suggest to get the codes for the items and research the market. I did another round of the analysis of the items, and I put an average price, American average price, that came down to $35,000, the $137,000 that they were charging. After that, the hospital keep calling me about what I'm supposed to do. There was a lot of pressure on it. And the last conversation I had said, you know, guys, that's my proposal. I did the research. This is what I consider fair. I want to pay you because I'm grateful for what you did. And this is what I can do. And then and I asked to talk with a superior person in the hospital, because I was part of just a number on a system. As no, this is my life. I need to talk with someone here at the hospital. They explained my situation. And then I finally got the chance to talk with someone for the upper scale there. So I just got here a few years ago. We're doing all right. I explained the whole situation. I tried to be transformed into more personal thing. And then, meanwhile, I thought that we didn't have any more space for dialogue with the hospital. So I called this guy here. And then we had the meeting for an hour, and I explained everything that I just said. And he told me this: you're doing good. Let's wait for the hospital answer, and then I can work as a mediator. And why I'm sharing this with you, because he was acting proactive before the lawsuit, and because normally we understand that the lawyers like lawsuits, take our money, and this is not the case. He wanted to avoid that and support my work. So let's wait, and if I need to step in to negotiate, I'll be happy to do it for you. But let's try to avoid any lawsuit, because I didn't want to sue the hospital that took care of my daughter. And yesterday, I got a call from the hospital. They accepted my proposal, $35K.
Wow.
And I was just thanking this guy, and I asked, do I owe you something for that? Because it helps me with my negotiation. I said, no. Congratulations. Now this is a good guy to have around. It's a lawyer, his knowledge, and also a good person. Thank you.